Hello everyone. Today in this video I am going to discuss about the procedure of postal ballot as per the Companies Act 2013. I have prepared this video on request of one of the viewers of my videos. So let's see what is the procedure of postal ballot. In my earlier video, I have already discussed about what all are the resolutions that need to be passed through postal ballot only and what does postal ballot means. For more clarity to it, you can watch my previous video on this topic. Let's start with the procedure of postal ballot. Postal ballot is given or is explained under section 110 of the Companies Act 2013, and the procedure is given in the rules and secretarial standards for general meetings. So as you can see that Rule 22 of the Companies Management and Administrative Rules 2014 read with para 16.3 of SS2, that is secretarial standard on general meeting. It deals with the procedure for postal ballot. Now what the board has to do for first of all, for passing any resolution through postal ballot, it has to firstly identify that what all are the businesses that needs to be transacted through the postal ballot, and then it shall approve the notice of postal ballot in which the proposed resolution has to be mentioned and the explanatory statement. Now what is the explanatory statement? Which actually explains the rationale behind passing of the resolution of the said resolution through postal ballot. Okay, so the first of all, the work of the board of the company is to identify the business and then approve the notice which shall state the proposed resolution and the explanatory statement to it. Secondly, this notice has to be sent to all of its shareholders, all of the shareholders of the company. The notice has to be sent to all of the shareholders of the company along with the resolution and the explanation of the reasons why this resolution is to be passed. And one more statement is required to be attached, which shall request the assent or the dissent of the members to whom the notice is given in writing on the postal ballot, and within how much time this has to be received back. It is within the period of 30 days from the date of dispatch of notice. So what is the time limit when the shareholder has to revert back either their assent or their dissent to the resolution? It is within the period of 30 days from the date of dispatch of the notice. Okay, I hope it is clear till now. Now thirdly, what the company has to do, the notice has to be sent, and now by which mode this notice is to be sent. So it is mentioned in the in the rule and the secretarial standard as well, that it can be sent either by the registered post or the speed post, which is the authentic way. Secondly, it could be sent either by electronic mode, that is through email ID, or it could be sent through courier facility. Okay, courier service, for facilitating the communication of the assent or the dissent to the resolution within the set period of 30 days. Now it is just specifying that the revert should come within 30 days. Okay, then now the notice has to, but obviously that the notice should be accompanied with the postal ballot form in which they have to write their assent or dissent, and also the instructions how to fill it, sign it, and return the same. Okay, because some of the shareholders might know how to fill or send, but for others also, for as a general instruction should be mentioned in that notice. Now who shall be authorized to conduct the postal ballot process? So it could be a company secretary, or if there is no company secretary, then any of the directors of the company. So for conducting the postal ballot, to sign and send the notice. Okay, so one of the important part of the postal ballot procedure is to approve the notice and to send that notice. Okay, so who shall sign and send the notice? It could be either the company secretary of the company or any of the director of the company who is authorized on this behalf. Okay, now once the postal ballot forms are received, then the work of the scrutinizers will begin. So for that, a scrutinizer have to be appointed. Okay, now who can be the scrutinizer? It could be either company secretary in practice, or CA in practice, or cost accountant in practice, or an advocate, or any other person of repute who is not in the employment of the company. So the basic intention of appointment of a scrutinizer is any person who is independent of the company. Okay, whose views are independent of the company. Okay, it shall be appointed by the board after taking his prior consent. So consent is important here. Unless and until the scrutinizer gives his consent, then he cannot be appointed as such. Okay, so because the work of scrutinizers is very crucial as of the postal ballot is concerned, so first of all the scrutinizer needs to be appointed, and it should be appointed only after taking his prior consent. Correct. Now, if any agency of e-voting is required, like if the company is giving the facility of e-voting, then the agency for e-voting would also be required. So if it is required, then it shall be appointed. Another thing, very important thing, which is mentioned here is that the cutoff date needs to be decided. Now, cutoff date for what? For recognizing the voting rights and ascertaining the members to whom the notice and the postal ballot forms has to be sent. So only to those members who are the outcome as of the cutoff date, okay, or who are reflected in the register of members as of this cutoff date, only to those members the notice and the postal ballot form shall be sent. So for that, like for recognizing who all members are there to whom the notice is to be sent, a cutoff date is required as on which date the members should be considered. So this is also to be decided before conducting the postal ballot. Okay, so till here it was very simple. Like the notice has to be approved. First of all, the board has to recognize that what all are the businesses to win for which the postal ballot is required. Then the notice is to be approved, notice is to be sent, company secretary is to be authorized, scrutinizer is to be appointed with his prior consent, and e-voting agency is to be appointed if it is required, and a cutoff date is required for ascertaining the members to whom the notice is sent. Okay, now another important thing is when the notice is given, an advertisement has to be published. Okay, now advertisement shall be published at least once in a vernacular newspaper in the principal vernacular language. Vernacular means local language. Now local language of which district? The district in which the registered of the company is situated. Okay, so an advertisement shall be published at least once in a vernacular newspaper in vernacular language of the district in which the registered office of the company is situated, and having a white circular in that district, and at least once in English language. Okay, so in two languages the advertisement has to be published. One is in the vernacular language and the other is the English language. Okay, now what this advertisement should tell, it should tell about having dispatched the postal ballot papers and specifying therein the following matters. Now the advertisement shall contain the following matters. First of all, a statement to the effect that the business is to be transacted by postal ballot, which includes voting by electronic means. Now, first of all, the advertisement should state that any business which is to be transacted by the postal ballot, it has to give the statement about that, and also if that business requires e-voting or not, that also has to be specified in the advertisement. Secondly, the date of completion of dispatch of notices, like what is the date when the notices have been dispatched. Okay, when the dispatch of the notice is completed, it has to be disclosed in the advertisement. Thirdly, the date of commencement of voting, from when the commencement of voting shall start. Fourthly, when the voting would end. Then the statement that any postal ballot received from the member beyond the said date, that is beyond the date of end of voting, will not be valid, and voting whether by post or by electronic means shall not be allowed beyond the said date. Okay, so why these dates are required to be disclosed in the notice? So that if the postal ballot is received beyond these dates, then it should not be considered as valid and voting should not be allowed. Okay, so basically this statement is also required to be disclosed in the advertisement. Then a statement to the effect that members who have not received the postal ballot forms may apply to the company and obtain a duplicate thereof. There is possibility that the courier or the post didn't reach them. So in that case, the advertisement would be useful because it shall also mention the statement that if any member has not received these forms, then they can apply directly to the company and they can obtain a duplicate form. Okay, now the contact details of the person is very important. Why? Because the contact details of the person who is responsible to address the grievances related to voting, which also includes voting through electronic means, then that details also requires to be stated in the advertisement. Okay, now let's move forward. If the company is having website, then this notice is also to be placed on the website. Okay, until when it has to be placed on the website? Till the last date of receipt of postal ballot forms from the members. Okay, then what shall notice specify? Till now we have read what the advertisement would state. Now I am going to tell what the notice will specify. It shall specify the day, date, time, venue, like notice of any other meetings through normal procedure, and the venue where the result of the voting will be announced, and the link of the website where such result will be displayed. This is very important because day, date and time, venue of the meeting is disclosed in every other notices of other meetings, but the venue here is just talking about is of the result, where the result would be announced. Secondly, the link of the website where such result shall be displayed. Okay, now it shall also inform if there is any e-voting facility available for the members or not. Okay, let's move forward now. So this is the procedure which the company has to do before starting the postal ballot requirements. Okay, so what are those? To send the notice, to advertise, to appoint the scrutinizer. Okay, so these are the main events which it has to do before the postal ballot actually starts off. Now, once the postal ballot is received back from the shareholders, then where it has to be kept? It has to be kept with the custody of the scrutinizer. And after this receipt of assent or dissent from the shareholder, this postal ballot is not to be destroyed or defaced. Okay, and even the identity of the shareholder is not to be declared. Okay, so now here it is talking about postal ballot once it is received back from the shareholder. Then what all the company has to do? Okay, then the role of a scrutinizer will begin. Right. Now the scrutinizer's role is first of all to keep all the postal ballots in the safe custody. Secondly, it has to ensure that there is no destruction of the postal ballot paper. Okay. Now, one more thing, I would clear it here only, that this receipt from the shareholder of the postal ballot should be within 30 days, as I have already discussed. Now, the scrutinizer has to submit its report to the chairman. Now, scrutinizer shall submit this report within 7 days. Okay, it has to submit it as early as possible, but it could not be beyond 7 days. Now, based on this report, the chairman or any other director who is authorized by him, he shall declare the result of the postal ballot. Okay, and the date, time, venue shall be the same as is specified in the notice. And what all other details have to be disclosed while declaring the result? It is the number of votes cast for and against the resolution, invalid votes. There would be some votes which would not be considered because they could be invalid, like improperly filled, and the final result as to whether the resolution has been carried or not. Okay, Such result has to be displayed on the notice board of the registered office, of the head office or the corporate office, and it shall also be placed on the website. Okay, so scrutinizer has to submit its report to the chairman or the director authorized by him within 7 days, and then they have to declare the result along with specifying how many votes are cast against and for the resolution, and whether the resolution is being carried out or not. And this result has to be displayed on the notice board of the company, either at the registered office or the head, sorry, at the registered office also, and at the head office also, and also at the corporate office if there is any. Okay, and it shall also be placed at the website if the company is having one. And once this resolution is passed, it shall be deemed to be passed on the date of the last receiving of the postal ballots from the shareholders. Okay, now another point here it is saying is that once the postal ballot forms and all the other related papers, registers, and the scrutinizer report which is received from the scrutinizer, once the process is done, it shall be kept with the safe custody of the company secretary or any other person who is authorized by the board for this purpose. Okay, so this is very important. Here the role of company secretary has been brought forward. I hope the process is clear and you have liked my video. This was on the request of one of the viewers. So if you have liked this video, then please like and subscribe. My YouTube channel is PH Webgyan Videos, and do not forget to share and comment on this video as your comments are valuable. So please do. Thank you.